Thanks for joining me in this Zoom and Learn session on, we're going to be talking about do-it-yourself versus professional wills, as well as what the big deal is with remote wills, assigning, as well as other documents. So thank you. I'm Beverly Carter. I'm a notary public. I was commissioned in 2013. As a notary public in BC, I have a master's degree in applied legal studies from Simon Fraser University. I have previous background as a teacher in small business and working in the government. And I always say I have 3 PhDs in life, which help me every day that I do my work. Just going to take care of a couple of housekeeping items here. So there is the chat option to use throughout the session to be able to ask questions. I may see them and either refer to them or deal with them at some point, but either way, you'll know where I'm going with that. And if you find this valuable, please share with your friends and family and on any communities in the Facebook board as well. Thanks. Our next Zoom and Learn topic is dealing with cohabitation agreements, and I'll be talking with Laurel Dietz, who is she's a family law lawyer in Victoria, and she's very progressive in terms of how she has been delivering legal services. But I'll be looking at it from my perspective in terms of being a notary and why it matters in my world. And Laurel will be dealing with that from the perspective of a family law lawyer. They're all the rage these days. They're really important, and I recommend that you tune in for that one and share it around. You know, people that would be interested in that might be people going into blended families, common law situations, parents buying with a kid for a house. There's a lot of different scenarios where there may be some interest in learning about that. Today's topic is covering remote signing, what it is not, who is the best option for. There are limitations around that, and we'll talk about practical aspects. And then we'll also be dealing with, do-it-yourself will kits, common errors that people make, why it matters to have a will done with a legal professional in BC. And then we have unique features of our Wills, Estates, and Succession Act, and then general estate planning and how to prepare for making a will. And so I'm just talking about remote wills in British Columbia in this Zoom and Learn series. So remote signing, what is it? So you've probably read in the newspapers lately that now we can remotely sign, but it's just not quite as easy as it seems. A little bit of a background in what this means is that we have 2 ministerial orders that are about a month old now, which allows notaries and lawyers in British Columbia to witness the signing of wills, enduring powers of attorneys, and health representation agreements in the electronic presence of clients. And they have underlined electronic presence because that is key in understanding what that means to us. So as a baseline, we have the Emergency Program Act. Currently, this is renewed every 2 weeks. That is the legislation, that is the law. And so the ministerial orders that we have, I've noted them, there's M161 and M162. They don't last forever. So they're only as good as long as we're in a BC state of an emergency. So that's sort of a key understanding of the law at a high level that helps us to understand some of the issues or interests that we have in and around the remote signing. So back to electronic presence. So wills, enduring powers of attorney, and health representation agreements. So I've specifically underlined enduring because there are different types of powers of attorney. Not all powers of attorney are enduring. So this specifically must be enduring. And enduring, the best way to understand that is it endures through any loss of your legal capacity. And I always say legal capacity is like mental capacity. What makes it legal are all the ticks in the boxes that we have. An example would be, do you know what you own? That would be a tick in the box. So we look at the whole person, assess their capacity. And so enduring means it endures through any loss of legal capacity or a permanent, either temporary or permanent. So temporary would be like this. You could go for surgery, you're knocked out, or you could have a permanent loss. Maybe you have a massive stroke and then have brain damage, and then you've got a permanent loss, or something like Alzheimer's. So signing in the electronic presence. This means that essentially, from a practical perspective, I'm here, I'm on one end of the video feed with audio, and you're on the other end of the video audio feed. And basically, I need to view you in that manner in order to be able to be electronically present. And a very common there's a lot of common misunderstandings right now of the remote signing of documents. And here's a really perfect example. These are the things that a lot of people think that they are. They think it's like an Adobe signature, which is a digital signature. This is not digital signature. It is very different from that. It is not DocuSign. Commonly, we will often use those with, like if you've ever signed a real estate agreement or things like that in that nature. Probably there is also financial purposes, mortgages. I think they're going more to some of those signings as well. And then there's another one called eSign Live. So this is not that. Remote signing is not electronic signing. The document must be paper signed. So we are using an old-fashioned ballpoint pen, and we are actually physically signing. So I'll be on one side in my room with the computer, and the person who is making the will, for example, will be on the other side. They'll have their ballpoint pen, and they'll have their paper, and they'll sign it. The other key factor is that this must be done with a BC notary or a BC lawyer. So it cannot be done with family or friends. And here's basically what the ministerial order states. At least one of the witnesses to a will must be a lawyer or a notary public, and the witness referred in subsections 2 and 3 must be a lawyer or a notary public, and that is BC specific. So these are not notary publics in Alberta or the US or anywhere else. In BC, notary publics are quite distinct in how we approach the law. So we are actually qualified to practice specific areas of law. We don't do anything contentious. It is not just a function of taking oaths or witnessing documents, but we practice in the areas of wills and estates, real estate, and contract law. So who should consider remote signing? People with health issues, those in the hospital or assisted living where maybe there are restrictions to getting in or out, those who do not feel physically safe, even with social or physical distancing measures in place, those who fall under any high-risk category. That can be age, it can be health, it can be an exposure issue to others, or immune compromised. People who live in remote areas who can't get access to legal services in a timely or easy manner. The best practice is still to do the documents in person wherever and whenever possible. So in my office, this is our remote process. So this part 1 is basically, I've been doing this for 3 months already. And we use any of the methods, Zoom, Google Duo, FaceTime. I haven't used Skype, but it is an option, or Microsoft Teams, I suspect. We identify our client, and we have different ways of doing that. And we need our clients to be able to have the technology available, and oftentimes they need support from family or friends to use it. So 89-year-old client who doesn't have one of these will often have maybe a neighbor or a grandson or somebody who will come and help them set up. And I've done nothing but this as a process, and it's actually been incredibly effective. I never could have imagined 4 months ago that I would be doing practicing law in this way and seeing my clients this way, but it's been excellent in the sense that a lot of people are so grateful to be able to be home and to get the service that they need. The gist of what I've been doing though, so that's the first part, and basically we're talking about very personal aspects of a person's life. We're talking about their wills, their powers of attorney, and health, and all the things that matter in their life, and the people that matter, and what they own, and what their debts are, and all those things. So we've essentially figured out how to do it safely and securely as much as we can. But the second part of that is that we still needed to sign with people. So for essentially until the ministerial orders came into effect a month ago, we still needed to see the person in the flesh, even at a distance. So I've signed in people's garages, I've signed looking through windows. Largely, most of the people have been driving in, parking in front of my office and staying in their cars, and we're signing, witnessing there. At that point, we've already reviewed all the documents at length and have approved them, so that made it easy. That is still my process, but where we've shifted to with the remote signing is all the technology required, but I still need to see the person sign. As I said earlier in an earlier slide, the law requires that it be a notary, a BC notary or a BC lawyer. But there are other aspects to the signing. So it was great when we could set up with, with a phone and just connect that way. But a lot of people don't have the technology to do the second part of that process. So do they have a printer available? And again, we also still need that audio-visual technology. One of the shifts in that is that we need to be able to shift the phone or the laptop in such a way that I can actually see them signing the papers. And that can be a bit of a challenge. And then just support with doing the physical paperwork, right? Getting it printed. So some of the people I have virtually seen have been in the hospital. Hospitals, we're able to fax documents back and forth, so they actually are easier to deal with. But if you're at home and receiving palliative care, often people are weak and don't, they may not have all of the equipment, right, based on age or income and lots of different things. So this brings up a lot of the practical matters that so far that I'm seeing. Either we've already experienced them, or I see absolutely the potential. So there's a lot greater complexity to doing the remote signing. I'm going to say that I think the wills are probably the easiest, but when you get into the powers of attorney, the enduring power of attorney, and the health agreements, they start becoming a little more complex. And so some of the things that we're seeing is that, sometimes the only person available, and we're looking at safe distancing, that person may also be a beneficiary or a named person in the document. So typically the practice has always been a person would come into the office, we're in a meeting room, I sit with them, and only whether it's a couple or just a single person. And so the space is controlled. And so part of that is a change, is that we lose that control, and yet we have the practical requirement to get the document done. So this is one area where we still need to maintain our professional due diligence, but it's a bit of a judgment call around looking at what it is that the client's doing. Are there any other risk factors, capacity issues, and whatnot? So another thing is getting ID verification. Are we dealing with the person that we're actually dealing with? I've certainly had a lot of people holding up their IDs, sometimes a little shakily, and they're a bit fuzzy. There are ways around that, but I need to confirm that the person is who they say that they are. And so it's not only just our traditional IDs. Sometimes if people are in a hospital, obviously they've landed there on short notice in some cases. They don't have wallets with them, but their wristbands would be an example of ID. So we have different strategies around managing that. This is one, the printer is not working, or it's low on ink, or it stops working. So that is one that we've encountered already. People have, they've stapled the papers together. So one of the features of doing the remote signing, which is quite interesting, and I'm going to say it took me a good week or two to really wrap my head around understanding the physical element of putting the paperwork together. So essentially, if I'm doing a remote will signing with you, you need to be able to print out that document, and then I have my own set, and they have to be signed at the same time in the electronic presence of each other, and then eventually they need to get to me, and then we put them together. Another thing that we found is sometimes people, they're dealing with lots of health matters, and they haven't really properly pre-read the document. So then I'm not really in a position to review the contents in the same way. I've always had the practice of wanting my clients to pre-read, have the time at home to ponder what's in the document, and allow them to ask questions, or even, you know, we're not perfect, so occasionally there's a typo. So looking for all of that. Another thing that can and does happen are changes to a client's health. So they may be having a cognitive decline. That can be from an illness, it can be from medications as well. They are weak. So there's the practical, you know, there's actually the practical signing. So you imagine if somebody's in a bed in a hospital and they're having to sign on their back and they're weak. It is really not an easy task. So we often, even when I used to be in the hospital seeing people, there's often a really strong element of supporting them to be able to sign as easily as they can on a firm surface. So we have clipboards and stuff like that. So we don't have control. I don't have all those tools available to me. So the people on the other side need to have that. Vision is another one. Not everybody has their glasses with them. So that can matter. So in some cases, what we've done is to do, I don't know, like 18 font or something to allow them to be able to read with whatever is available to them. So that seems to have worked. So this is another one. If there's any last minute changes, you have the potential of having incorrect version of the signing document. So this goes along with not having pre-read the documents for lots of reasons. But it's important that if you're for a will, and I'm just talking a will, so if you sign your will, I sign my will, they have to be exactly the same, or else they will be invalid. And so so the preparation I'm finding is quite substantial to make sure everybody is on the same page, literally. Another practical matter is if the state of emergency ends. So right now, you know, we go, I think the last one was last week, right? Tuesday. And so we have to wait until Tuesday to find out if this is another, you know, do we have the next 2 weeks? So if I saw a client on the Monday and we don't know until Tuesday whether or not the state of emergency is going to be extended, I don't know if I'm actually going to be able to remotely sign with that person until the Premier announces that our state of emergency has been extended. And the law only allows them to extend it in 2-week increments. So if we get to the next, I think it's a week today, next Tuesday, the 23rd, and we find out that I've seen a client this week who totally needs a remote signing, but then they choose not to extend it, I have a real predicament on my hands as to how to manage that. So being responsive, timely, and aware of the current legal structure really matters in my world. I mentioned slightly earlier the return of the signed document. So once a person has signed, I need to get those physical copies, and then we put them together in tandem as one whole document. So essentially, instead of having one single will where normally we would all sign, me and the client, me as the notary, and another person as a witness, in my world, we're ending up with 2 because one of my witnesses is my assistant. And so we're in the same place and can see each other, and then the client is on their own. So then we have 2 copies of that will. But possibly if we couldn't get a witness two witnesses in the same place, there's the potential to have 3 copies of that will, making for one single copy. So multiple party signing, that's a bit, I've just touched on that. This is incredibly complex when we get to things like enduring powers of attorney, especially. The reality about enduring powers of attorney is they're a very powerful document, but if we have a perceived or expected need for it to be used on short notice, it might be that I'm in Victoria, my client is in the hospital here or anywhere in the province really, and the attorney is in Prince George. You know, the complexity of signing those additional parties, just this was the part that I really scratched my head around, because there's different laws that impact powers of attorney. This is not easy at the best of times when you have control over all the parties and they're signing. This level of complexity and the potential for issues and errors is really, really high, which essentially means liability for us and the inability to potentially use that document in the way that it should be used. So remote signing isn't all that it's cracked up to be. We also have things like, we've seen tech issues, frozen screens. I'm finding in general that any video communications with people, there's, depending on the time of day, there are definitely a lot more people using it. So internet connections aren't always stable, and the video quality can be poor. And so ultimately, if a remote signing is done by a poorly trained or unqualified person, legal or otherwise, and I mean otherwise in where people think, oh, the neighbor can just put this together because they read that we can do remote wills. No, they're unqualified, that the document can be done wrong. So we have frequent sessions on keeping us up to date on the practicalities of the documents being used for any real estate, for example. We're getting feedback from the head of the Land Title and Survey Authority, and these are the things that go into my head that allow me to help you to be able to get these documents. I'm still going to go back to the best practice is to sign in person. But if it's not possible, you're in a high risk category, and we're able to do it because the law still allows it and the ministerial orders are in effect because of the Emergency Program Act, then, you know, we will absolutely do that. And we've done a number of them now, and we have worked out some of the bugs in and around. Basically, we're trying to set it up for success, but it definitely takes a lot more people power and knowledge and staying on top of that knowledge, that legal knowledge, to be able to make it work for sure, and the technology. So is there anybody out there who has any questions? That I'd be happy. I didn't really see any come up. I'll have another session at the end. We're going to shift into do-it-yourself wills versus professionally done wills, which sort of remote signing, I think I've touched on why it has to be a legal professional doing it, because the law says. And I'm not seeing any, but so here we go. We're going to shift over here, I just said. So I'm going to talk about this because I get a lot of common questions and comments. Can a notary do a will? And that's BC specific, because notaries in other parts of the country, Quebec accepted, and US, do a much more basic common function. I do that. That is a part of my business, but a large part of my business is doing personal planning documents like wills, powers of attorney, health agreements, and as well real estate for people doing purchases, sales, new mortgages, those sorts of things. And we have in Victoria a lot of people from other parts of the world, other parts of Canada, who don't really understand the notary function in BC. So that is essentially what we do. So we are qualified under the Notaries Act in BC. And that is one of the differences between a lawyer and a notary. And lawyers are qualified under the the Legal Professionals Act, sorry. And essentially lawyers come out as generalists when they finish their law degree, and then they can specialize. Notaries, we do a master's degree, and we come out and we can only do specific areas of law. So in effect, for real estate, it's roughly, we can do the same thing that they do. We don't do anything contentious. For wills, we could do 75% of most people's wills. Where we differ is in the area of trusts. And so we can do a simple trust where children or beneficiaries who are minors when they age out at 19, or when the youngest of a group ages out at 19. That's the biggest difference in that area. Powers of attorney and health agreements, there's no difference. Why should you use a notary or lawyer instead of a do-it-yourself? Well, we're going to talk about that. These are common examples I see. My will is simple. I have a later slide, but I'm going to share it with you here. I say, your will may be simple, but your life isn't. And it's really, the life isn't that simple, or the potential for changes in your life, a lot of people don't understand. So I had a Zoom interview with a client a few weeks ago who says, oh, I have a perfectly good will. And I'm like, okay. And she said, yeah, it names my ex-husband as my executor, and I'm giving everything to him, and then if he dies, it's going to my kids. Well, and she's had this will for 17 years and has also been divorced for 6 years. It is not a valid will. Parts of it are valid, but essentially it is not. So not everything is straightforward. Not everything is simple. People's lives change. I don't have anything. So most people have at least a bank account. They may have a car. They may have other things. The will allows you to appoint your personal representative, who we commonly think of as your executor. Also, executor and trustee is another term for that. They have authority with regards to you and your estate from the moment of death. The absence of a will leaves it all up in the air. And when people are grieving, that is not the time to have to figure this out. So even if you don't have a lot, one of the basic functions is dealing with your body. The other things would be doing final income taxes, closing out accounts, and stuff like that. And with the executor appointed, you have that from the get-go. Otherwise, it's up in the air and may require a bunch more paperwork depending on the size of the estate. Another thing I hear is giving everything to my sister. She can give it to everybody else, or some version of that. That's a trust, right? And you know, it really matters that you get your assets to the people that you really want them to. These things are fraught with issues, because what if that sister is going through a divorce, or in the future ends up going through a divorce, and you've just given her $1 million? Well, potentially that $1 million can be on the table for an ex-spouse to make a claim against. And so you lose control when you add in other elements like this. There is ways to structure the will to get it to the person that you need, and that's a much better guarantee than giving it to somebody else. And I've done my own will. I just need you, the notary, to sign it. So no notary and no lawyer is ever going to sign somebody else's homemade will. The liability is too high. I basically see on average 1 to 2 homemade wills a week. And I'm going to say at a minimum, 4 or 5 of them have grievous errors. It's kind of shocking. And people just think that they know what they're doing, but they really don't. How many people have wills? So just over 2 years ago, there was 51%. And if you look at this Angus Reid poll about wills and testaments, that's where that comes from. Certainly since COVID-19, I can absolutely attest, in March and April, the phones were ringing off the hook. A lot more people have wills now. I have no idea what the numbers would be, but if that went up to, I don't know, 60%, I don't think that would be an unreasonable guess. Just a guess. April the 13th, so this is 2 months old now, but the Time Colonist ran an article for the demand. A lot of the changes seem to be triggered by high visible people being announcing that they had been tested and were positive for the coronavirus. And you can see one online wills company in the first 8 days of April saw a massive increase in their traffic. So are these wills good? And why would we even ask that question? Well, I've already said I see 1 to 2 homemade wills a week, and at least 4 out of 5 of them have grievous errors, things missing. One I saw last week, somebody had, what had they done? They had done the first page, and then they had signed the last page, but forgot to sign. And then they slipped in something in between, like they changed their mind about what they were doing. It had been unstapled and stapled again. So absolutely, people have no idea how to treat the authenticity and integrity of the document. These are common things I see. They're marketed as DIY wills, will kits, online wills, free last will. I do see sometimes charities or funeral memorial institutions telling you how to create your own will. They're trying to do it from their perspective as a value added to get you as a customer. I'm going to tell you that, you know, you shouldn't, there's very few people where a homemade will works. There is the odd situation, but generally, I just state here, lawyers love homemade wills, and I've heard this particular lawyer say that numerous times in different versions as well. But essentially, there's so many errors and issues that it's the lawyers, and it's not the lawyer's fault. The person who wanted to save a bit of money, who decided that they knew how to do this and trusted the online forum to provide them with a proper legal document. But it's the lawyers who have to fix those problems, who have to put it before a judge in a court, and they need to know all of that. So here's a fun little comic. So where the will was done wrong, and one side, the wrong side got all the money, and the blonde got all the brains. So there you go, the husband's brain. Thought that was kind of cute. Oops. Hang on here, it's all right. All right, so common mistakes that we see are choosing a bad executor, and that's not to say that the person is bad. It just means, for example, they could be in India, or they could be in the US. I've put a link here because we do know that US-based executors, there's some very strong issues around being a trustee, owning foreign property, the tax. It really complicates it. So it's really about choosing the wrong executor. Some people will also choose the oldest child because, you know, that way they don't have to deal with, you know, the dynamics of the decision. And that's not always the best decision either. It's more about choosing the right person who's capable of doing the job. Common mistake is forgetting about the kids. I've talked to people who have kids from previous relationships who basically they've been estranged for decades, haven't seen them in 40 years, have no idea where they are. Well, they're still your kids and they can still challenge a will. So BC has the Wills, Estates and Succession Act, and we have this unique feature where people in certain categories can challenge the will. And this is why forgetting about the kids, you know, did you forget about them because you're losing it? Or did you forget about them because you haven't seen them? Or did you forget about them because you don't want to remember them? Or they've been, you know, not much fun, or you're estranged. You forget assets. Or you forget how you own your assets is a good way to do this one. People don't realize that, you know, 2 people own the house and they can't just give it away. Because 2 people own it, and if one of the people dies, you can't necessarily be able to give that away. They forget about other financial considerations, forget details. Well, which ring is it that you're giving? You have 50 rings or necklaces, or, you know, car. Oh, I want to give my car, but you have a car, a truck, an SUV, who knows, right? So details matter. Getting the facts wrong, I think those are just errors of details. Not, I saw one last month where the people had intended to give, they were giving everything to each other, and then in the contingency plan, the what if plan, or when the second of the couple dies, the intention was to give 50% to one side of the family and 50% to the other side of the family. Well, they got it wrong, because they ended up giving 50% to one side of the family and the other 50% back over to that family. So they really wanted a balanced approach, but they didn't get that. So that's detail, and it's also facts. Accurate names, you know, what version of John Smith are you? I'm going to say the most frequent last name I see, certainly the English or anglicized names, would be Smith. And it's signed incorrectly. That's a very common, it's not witnessed properly. People don't put their details. Well, how do I know whose scribble that is? So, you know, there are legal requirements for wills. I talked about this one earlier, giving assets you don't have the right to give. So a common area for that would be blended families, where you know, they may move and they buy a property together, but really the money and all of the wealth to buy that particular house is from one of the couple. But that person says, I still want to give this house to my kids, but they don't realize they've set that up as joint ownership. And the nature of how you own your assets really factors into all discussions. So joint ownership would be the right of survivor. So the surviving person keeps the asset. And you'll see that on cars, bank accounts, houses. And a lot of people don't realize they can't give that unless they're the second to die. If they're the first to die, they don't have the right to give that. Giving to the wrong person, I'll give you an example of that. Giving all the 50% to that one group, and the next 50% also to that group. Bad or ambiguous language. Had one client who spent well over $15,000 in legal fees just because the homemade will was done by an accountant who ought to have known better, who created some ambiguity. And I remember looking at it and I said, well, I kind of think you know where they're going, but it's not crystal clear. And what that in effect did was it opened the will up to being, it exposed it to other people to probably or perhaps inherit that money. And it also happened that person they were the beneficiary, they were also the executor. And so it was quite challenging. So missing key clauses, I see this a lot. This is probably the biggest thing that, this is probably the biggest thing that I see is people say, oh, I don't understand that legal mumbo jumbo. It doesn't need to be there. It's just beyond what you know. And they cross it out, they take it out, or they delete it. And it's not true. There's a reason why a lot of things are in there. And controlling from the grave is another common issue. You can't give $10,000 to your kid and make them wait until they're 50 to get it, because they're already 40. So, you know, you either give it or you don't. You need to, or if you have enough assets, then you need to see a lawyer who can create a trust. Then you can do that, or you can look at different strategies. Forgetting the contingency plan. So what if that person is not there to get that gift? And trusts, I just touched on that. So trusts, you know, if you have a child or a dependent who has a disability of some sort, who needs, you know, frequent money but not a lot, those are reasons why you would have trust. Lots of money, lots of complexity, owning businesses, so there's different things. So to summarize, what I really basically see is people don't know what they don't know, and they don't know what they need to know in order to get a do-it-yourself will done right. And the potential risks are you can frustrate the will or some of the terms. So an example of that is like oh, I'm going to give $20,000 from my RBC bank account. Well, maybe today you have 20,000, or maybe you have 50,000 in it, but at your death, you might have closed that bank account. And so what does that mean? Did you want them to get 20,000? Some people are very clear. They want it, whatever's left in an account, they'll get, and others are just not so clear. Can invalidate a will. It may not be the will that you really wanted. You end up with a poorly executed estate. So that can be because not the right executor, can be you have issues along the way that need to get corrected, and it takes forever and a lot of money. You have a complicated, you make your estate complicated by adding in these measures. Are you missing a will? So people who do it themselves typically do not register the wills in the BC Vital Statistics Agency. And one of the things that I do that as a best practice, because then we know concretely that you have a will, that it was done on June the 16th, 2020. And so if you found an older version of the will, you go, oh, that's not the will. Or you say, I can't find the June 16th will, I need to look harder. Or maybe they did a will after that wasn't registered. It can really cause some confusion over which will you're going to use. And if you don't have a will to be able to use, or no copy of it even, you can end up going to what the law states. The law will define how your estate gets distributed, and that may not be the people that you want, or it may be the people, but not in the right. You may only want to leave 20% to one person, where they may end up being 50% in another scenario. So it really matters. And so these are the different things I talked about. This different beneficiary potentially can inherit. That can be either for not having a will, or like I talked earlier, the one client of mine who the ambiguity in the language opened it up for somebody else to challenge the will. And these are BC specific, unique characteristics in doing a will. This may not be the same in Alberta. You have to base everything on the law that we have in here, in our province. So wills variation challenges under Section 60 of the Wills, Estates and Succession Act. And then the other thing is, people are already grieving when you don't want to add any complexity on top of that. If you have any dynamics or fractures in a family, those are going to be emphasized, and they may not ever be able to be repaired. So the best thing is really to be prepared as best as you can. You may still get some of these aspects in place, but at least you've done your best to leave them with a will that you want, and not, and if they're going to be how they are, they're just going to be how they are. But you can mitigate that. And as a notary, I take substantial notes, and particularly in certain circumstances where there may be some risk to a will being challenged. Common scenarios are blended families. So this is really interesting reading here. If you're interested to look at disinherited.com, Trevor Todd is a leading estate litigation lawyer in the Lower Mainland. And so he's got an excellent up-to-date website called disinherited.com. That should scare you from doing it yourself. And then BC Estate Litigation is also another source. When you should not use it, you have a blended family. Blended families, so in BC we have people who are legal beneficiaries who are in a legal position to potentially challenge your will, and it will depend on how you own your assets, what your objectives are, and what your will states. So it's not just one thing that we look at, and whether or not you considered all of these factors, the relationships, the legal or moral requirements that you have. And so blended families absolutely need to understand the law. If you're getting married, you need to understand how this impacts your estate. Common law spouses. So in BC, common law spouse is defined as living in a marriage-like relationship for 2 years. So think about that. That's not a very long-term relationship. So if you have a child who's getting an inheritance from grandpa, and it's $500,000, and they move in with their boyfriend, girlfriend, whomever, and they get the inheritance, but then after 2 years, that person becomes a common law. You know, there's also elements of family law. I can't speak to that, but you should always be aware of the family law element in that as well. But in my view, as a notary, when a person dies, that person may end up getting that inheritance. And it may not be a great relationship. It may not be a hugely committed one. It might be easy. And so it's important to understand what common law means. If you're separated from your partner or spouse, you need advice. Like, we talk about all kinds of practical aspects of the will, what you have, who have you got in your natural groups to choose from, and who's best qualified. Trustees of minor children, you know, you don't choose somebody 80 to manage a trust for the next 15 years. So, you know, if you own or will inherit, so that changes up your wealth. If you have minor children or dependents with special needs. As a notary, if you have any dependents with special needs, you're better served by seeing a lawyer. All that may depend on how much you own as well, whether or not you need to set up a specific trust or not. If you're dealing with a serious health diagnosis or recently been in the hospital, you know, you might be kind of distracted, or you might have, you know, the estranged child who, you know, kind of parachutes in after not seeing you essentially, or not really having any substantial relationship after 15 years, and now trying to run the show when there's others locally who have relationships. So we try to rule out sources of influence, and we need to assess capacity. We need to be able to defend that, because a person can challenge it based on you not having capacity. Family dynamics of any kind. You all know the stories, and if you have beneficiaries or executors who live in other countries. Also, if you own a recreational home, rental property, or business, you need dual wills. So I'm not going to get much into that. You cannot have two wills in BC, but I have done wills where it's for all of the world excluding the United States, and the people will have a separate will just for the United States. There's usually assets held in the States why you would do that, and you want to simplify some aspects of your estate after death. Forgiving debts to kids, you know, maybe you gave $50,000 to one for buying a house, and you want to forgive that, or you don't want to forgive that, you want to note it in the will. If your children are unable to handle a large inheritance, so that speaks to trusts mostly, but these are things that we talk about. You want to disinherit somebody or leave a different amount. You want to leave to someone who can't manage themselves. You know, I see people who have kids who have been, you know, addicted. They have addictions. You know, maybe they've become clean, but they just want to protect them as best as they can. So again, they can do trusts. You want to save money. Not a reason. Often you don't save money. You're in an urgent situation. You know, what's the urgency about? Is it your urgency because of a health diagnosis, or is it, you know, are you the aunt and your niece is creating an urgency for you to get something done because maybe that niece is wanting to get what you own? You have contractual or other obligations in life that may be affecting your gifting. So this is, I spoke earlier and I gave, it's this coming Friday where we're doing this session on cohabitation agreements. So, you know, that really matters because the end of a relationship can be death, and that's why it matters in my world. And I need to understand what contractual commitments do you have in your life. So that also applies to a separation agreement. We look at those to determine what we can or cannot do. And a common one, if we're looking at separation agreements where people have pensions, they may have had to divide half of a pension to an ex-spouse. So it changes how much wealth transfers as a result of your death. If you die without a will, the courts will decide, well, really not the courts, the laws already states who it is, but the courts will decide who your estate administrator is. And essentially somebody needs to step forward with the correct paperwork to get that done. And I have a brother who died a year and a half ago, and this is, I mean, he's not a person you could have told much to, and he certainly died unexpectedly. And so my niece was having to step forward as the administrator. And a year and a half later, a lot of stuff is still not done. It's complex. The courts will decide guardianship of minor children if you don't have a will. Distribution of your estate may be delayed, likely will be delayed, because you have to go through certain hoops first in order to prove that you can then administer the estate. You've lost the opportunity to ensure your assets go to the people that you want, or charities, or nonprofits, and in the manner in which you want. The law defines what happens to your assets. So wills are important. They appoint an executor, they create a trustee, they give away your assets, and they pay your debts. And they do what you want to do. It's a tool created within the context of a person's life. So as I said earlier, your will may be straightforward, but your life isn't. And most of us don't have straightforward lives. I'm going to say at most, maybe a quarter of the people I see have straightforward lives, and that's at most. So I mentioned earlier, we have the BC, in BC, we have the Wills, Estates and Succession Act. It defines the formalities required in a will. It defines that we can have wills fixed. So if there's some errors, like a missing signature, or when something clear, you can kind of tell what it really was trying to do. A judge can make an interpretation on that. That costs money. It defines who the legal beneficiaries are. So essentially spouse, children, parents are defined as legal beneficiaries. It also defines that if you die without a will and you don't have a spouse, you don't have parents, you don't have kids, it defines who would get your assets, and in how much, in what degrees, defines who's a spouse. And now it's complex because we have the Emergency Program Act and those two different ministerial orders. Why a legal professional? We are trained in drafting wills. We understand the legal language. We are insured. We assess capacity and rule out things like undue influence. We look at you in your context. We look at how is your life made up today? Dynamics, blended families, the quality of the people you're appointing. We look at the big picture of how assets are structured. Not all assets pass through the will. And a lot of people don't really realize that you can have a life insurance policy that's $1 million and they try to give that through the will, but you've already given that to one person over there. You can't then take that same money and define it in the will. Well, you can, but it's complex, and you don't necessarily want to do that unless there was some context for changing that up. So these are the things that legal professionals will talk about. What gifting or tax strategies have you got considered? And basically, we look at estate planning from a professional view. We contemplate the situations that you've never thought about and offer different types of options. And that is something I hear frequently. Oh, I never thought about that. Oh, I never thought about that. Oh, I'm so glad that we're talking about this. And that's what we do. We want to set it up for success. So my particular practice is I use a will questionnaire. This basically allows you the time to prepare for the appointment ahead of time. Provide me with details. As you can see on that first page, there's practical information like your name. But believe it or not, I'm going to say half the people don't either know their real legal name, don't want to use it, or use some other version of their name. And these things matter in our discussions. And so you can find Will Questionnaire on our website if you are so interested. And any questions or I can answer right at this time. So I'll just pause for a moment to see if anybody puts their hand up. Aha. Hang on. So Tracy has asked about the costs of wills. I'm going to take that as a general take on it. Usually most legal professionals will have a base fee. Essentially, if I'm doing a will interview, I have 1 hour, a minimum, that I meet with the clients, and then I have notes that I have to take after that. And then we have the follow-up signing and all the administration around that. So, you know, you can, depending on what you're doing in the will, they can really vary from, you know, $350, $400 up to $1,000. For more complex situations, that would be just a range. Lawyers, you know, and let's put it this way: you have the cost, but what do you save, right? So you get it done right. You've got a professional who puts it together for you, who considers all the different options available to you, who assesses your capacity, and who is basically, I look at this as somebody down the road may challenge your will. I have no idea what the context of your life will be in 20 years, but I know what it was like today, and I know what we talked about. So, so essentially, it will just depend. Also, whether or not you're couples, whether or not you're doing mirrored wills or different wills, those are all different factors that come into place. It's not unreasonable to have a file fee for any legal practitioner. We have very severe file retention policies around how long we hold our documents. And essentially, I treat each person as a file. So if I do a will for you, it's a minimum of a 10-year commitment to keep my documents related to doing that will. And that would be assuming you died the next day after signing it. Essentially, we keep the wills for 10 years past the point you turn 110 if we don't know when you've died, or 10 years past the point that you die. But if your will requires probate, and probate is the action of submitting to the BC courts the last will and testament, along with all the paperwork, and the judge saying, I grant probate, and that's the approval for the executor and trustee to then go out and administer the estate in accordance with the terms of your will. So it's 10 years past that point. So very long file retention policies. One of the other things I do, if people own real estate, I will always look at the out of the land title registry. I will pull a copy of the ownership papers, and I do that because there's different issues that will come up. One is that there's a known glitch over about the last 10 or 12 years, where sometimes the joint ownership gets dropped. I found it about 7 times last year. In 2019, I think I've not even found it once this year. So that impacts your estate. And then names are wrong often. And do you own jointly or as tenants in common? And tenants in common is like a share ownership. So we look at all of those things. So I hope that answers that question. And seeing none other, I'm just going to say if you need to contact me for any reason, you can reach out to hello@Carter Notary. And just a reminder that our next session on cohabitation agreements is happening on Friday at 10 o'clock, and with Laurel Dietz, who is a family law lawyer in Victoria. So thank you all, and have an awesome day.